understand the single assignment system in federal court, you really have to begin with how the chambers are set up and who it is that occupies the chambers, because that's where where the big differences arise. The judges, as you know, are appointed under Article 3 of the federal Constitution, and they will stay in office for life as long as they are on good behavior. And they are supported. They're the stars of the system, but they have a big supporting staff. Every chamber has a secretary, usually 2 law clerks. A courtroom, the law clerks are recent graduates, usually from law school, who graduated high in their class or have done a good job in law school. A courtroom deputy, who is a permanent assignment to that judge and knows exactly how he or she runs the courtroom, and who is in contact on a daily basis with the people who receive the files and receive the pleadings that you file with the court. And they are often supported as well by one or more externs who are students in law school, but who are given law school credit to work with the judge for a semester, the judge and his or her staff. So, as compared with a state court judge, who must often struggle mightily with less than a full chambers from time to time, the typical federal court judge is blessed with a tremendous supporting staff. And the result is that pleadings that you file, the appearance that you make in federal court, will be evaluated at least twice. Once by a law clerk or an extern, and once then again by the judge himself or herself. This is a key ingredient of the single assignment system, because what it means is that that judge will evaluate you from the very beginning of the case. Because when you are assigned to a judge in federal court, that judge will have your case forever. Barring some very unusual circumstance, the judge will see your case from beginning to end. And so every pleading you file, every appearance you make, will make an impression on the judge and his or her supporting staff. In addition, there are federal magistrates. These are persons who are appointed by the judges. They are lawyers in private practice who've chosen a judicial career, and they often will be assigned to your case and will follow your case all the way through as assistants to the judge, in a sense. And they will work on law and motion matters and are able to work on other matters by stipulation of the parties. And they too will follow your case. They too will evaluate your pleadings, and they too will evaluate you and your case from the very beginning. So there's how the chambers work, and that's why the single assignment system is so important. Even in those counties where the Trial Delay Reduction Act is in full force in state court, the state courts have yet to catch up with the federal courts in terms of fine-tuning the way this system works. There are a couple of other differences I want to touch on briefly, but before I do, let me turn to a few books, a few references you really need to have in view of the single assignment system. You want to perform well for these judges, law clerks, magistrates, and others. And the way to do that, obviously, is to have a copy of the Federal Rules of Civil Procedure and 28 United States Code, which is the statutory provision that governs much of what takes place in federal court. There are 2 other books that I think you really need to have in any library in order to practice in federal court well. One is the local rules of whatever district you're in, and I'm referring now to the local rules of the Northern District of California. The copy I'm holding here is in a small blue cover. You should know that these rules were recently amended, effective 1988. And so if you're operating out of the old rules, you should write to the clerk of the court, and I will give you that address in a minute, and get a copy of the new rules. There are some changes, and we'll mention some of those changes tonight. But they have changed some of the practice in the local courts. In addition to that, there is a book that I'm now referring to, which is called the Northern District of California Courtroom Procedures Interview Project. This book was an effort by the lawyer delegates of the Northern District of California Judicial Conference to talk to all of the judges in this district and to find out how they like to operate their courtroom. And they talk about everything from the nature of the pleadings and the form they should follow, how oral argument should be conducted, how jury voir dire should be conducted, every element of the courtroom proceeding from beginning to end. Both the local rules and this interview project book are available at the following address. Let me give it to you. I'll give it to you twice so you can write it down. The Clerk of the United States District Court, 450 Golden Gate Avenue, Box 36060, San Francisco 94102. That's Clerk, U.S. District Court, 450 Golden Gate Avenue, Box 36060, San Francisco 94102. And I will have these up here during the break if anyone would like to come and take a look at them. I've talked about the single assignment. Let me spin through a couple of other fundamental elements of federal practice that we won't talk about as much tonight that I think are distinct from state practice and that I would think all of you would want to bear in mind. Discovery and pleading in federal practice can be easier than under state court practice. The federal system is one system. It is possible to take depositions, for example, out of state without going through a cumbersome commission process or some other process. In terms of pleadings, federal courts follow what's called notice pleading, which is in many cases less restrictive than code pleading, which we follow in state court. Certainly in terms of filing complaints, it's easier. Answers can be a little trickier in federal court since you must answer or deny each of the averments that are set forth in the complaint. But generally, pleading is different and easier in federal court. There is a high standard of care imposed upon you in all courts, of course. But the federal courts have a rule called Federal Rule of Civil Procedure 11, which says in essence that when you file a pleading in federal court, that you as the attorney verify that the pleading has merit in law, in fact, or that it represents a reasonable extension of the law. And you must be careful when you file a pleading, if you're extending the law, that you make clear to the judge that that is in essence what you are doing. This Rule 11 is the subject of a lot of judicial activism in some cases. Certainly a lot of appellate opinions have come down. I ask you to be aware of it in your own practices. In the Northern District of California and in many other districts, there is a mandatory arbitration provision, and if you're not used to practicing in federal court, let me ask you to take a look at it. In this district, any matter that's worth $100,000 or more is subject to mandatory arbitration. In other words, a fairly significant piece of litigation could go to a mandatory arbitration process before it ever made its way into a jury trial situation. So be aware of that if you're in federal court. And finally, let me touch on the issue of juries. In federal civil practice, 6 jurors, plus as many alternates as the court may determine, will be the ones who decide your case. 6 jurors. That's not as many as you have in state court. And if you're the plaintiff or a party with a burden of proof, you must win all of the jurors, not just 3/4 of them. In federal court, you must win all of the jurors in order to prevail. Voir dire is done in federal court much more by the judges themselves. You will submit your jury voir dire questions well in advance. The judge will decide whether he or she is going to ask them and in what way and in what order, and the judge will decide whether he or she will supplement those jury voir dire questions. This is very different from the practice in some state courts. And finally, this is not something that many people think of, but consider it, the demographics of the jury that you may get. The federal district in the Northern District of California covers a wide variety of counties, and all federal districts do. Here we will reach not only San Francisco County, not only Alameda County, but also into Contra Costa, down into southern Alameda County, up into Marin County. And the result is that the demographics of your jury, once it is selected, may be somewhat different. The prevailing wisdom is that juries in federal court here tend to be somewhat more conservative than juries in state court. It's a matter you would want to consider before you went into federal court, assuming you had that choice.
Since so much of the case and the way a case is handled in federal court depends upon which judge you get, we have to talk for just a minute about how the judge is selected. And a little bit about how, if at all, a judge may be disqualified, and what the Northern District of California does with a series of cases that may in one or another way be related. Let me talk first about how the judge is actually selected. The short answer is the judge is selected at random. In the Northern District, which is the focus of our presentation tonight, we currently have 17 judges and 6 magistrates. Of the 17 judges, they will be selected through a completely random process, and there's no one I know that's figured out a way to predetermine who's